My Lord, my lady, if it may please you, my name is Milimo. My Lord, I'm here to address you on 3 grounds. Specifically, my Lord, one on public participation. The second issue, my Lord, I'll be addressing you on is fair hearing, with reference, my Lord, to the National Assembly. And lastly, on the nominee, my Lord, the Deputy Presidential nominee. My Lord, on the first point of public participation, you shall note first, my Lord, that there is no one in the petition before you who has alleged that they were denied an opportunity to participate in the public participation exercise. The second point, my Lord, is that it's common ground to all the parties that public participation was an essential ingredient in the impeachment proceedings. And that is, my Lord, dictated by Article 118B of the Constitution. And my Lord, on the boxes to be ticked in reference to the public participation exercise, I invite you, my Lord, to refer to the Supreme Court BAT decision. And specifically, my Lord, at page 45 of that decision, which we have attached, my Lord, to the first respondent's supplementary list and bundle of authorities dated 28th of this month. My Lord, the second authority that I will refer you to on matters public participation is the recent authority, my Lord, that was rendered last week by the High Court in the affordable housing decision, my Lord, that is petition number A154 of 2024, and specifically, my Lord, at pages 178 to 179, rather to 184 of that decision. My Lord, if you are to refer to the replying affidavit of the National Assembly, you will note that the National Assembly, my Lord, undertook an unprecedented public participation exercise. None of that nature and magnitude, my Lord, has been undertaken in the history of this country. And my Lord, I will refer you to the annexed public participation report, and specifically, my Lord, at pages 427 to 555 of the replying affidavit of the National Assembly. And my Lord, very quickly, you note that over 224,000 people over 224,000 people were involved in the exercise, where they volunteered to give their views. And out of those, my Lord, you shall note that 65% of the people who rendered their views were in support of the motion.
Is this submission for the lifting of orders or for petition?
My Lord, I'm trying to establish the fact that heavy weather was made, my Lord, on the fact that there was no public
We have noted those heavy weathers, but you know, we need to be, because we are all lawyers and judges, we need to be specific to the issue before the courts. Some of the things which you say here are actually not meant for this forum. We've been trying not to intervene, but you know very well that a lot of submissions which have been made here are not for the proceedings today. They are meant for another proceeding altogether. So if you can just avoid them, the better for us.
Yes, my Lord, I stand guided. And then that...
In other words, Mr. Milimo, you may spare us a submission on the sufficiency of the public participation.
Correct, my Lord. Yes, my Lord, I stand guided, and I was just going, my Lord, to refer you to one authority that we had, my Lord, attached as authority number 1 in the supplementary list of authorities, if you are to look at page 4 of that authority, my lord, the sufficiency or otherwise of public participation exercise, my lord, is to be determined at the main trial. And my lord, therefore, I would agree with you that all I need to do, my lord, is to refer you to the report that I've indicated, my lord, that it appears at page 427, specifically the findings, my lord, to 455 of the replying affidavit. But my lord, allow me just to pick one thing out of that report. You are particularly, my lord, referred to one of the constituencies, specifically, my lord, Keio South constituency, where my learned colleagues, my lord, raised issues that indeed the figures did not tally. My lord, first, you shall note that the figures that were quoted by the petitioners, my lord, are contained nowhere in the public participation report that have been submitted before you. My lord, I want to believe that my learned colleagues got that information from sources other than the report that was submitted at the National Assembly. My lord, Keio South views, my lord, are submitted are to be found firstly at page 289 of the report, my lord, and it appears as item number 95. And this goes specifically, my lord, to the hand-delivered and email views, where it was indicated that, my lord, there was a total of 465 responses, and out of those, my lord, 455 were in support. That is what, my lord, is contained in the report as the first limb. The second limb, my lord, is for those who participated in the public hearings of the 4th, my lord, of October, and is found at page 331. Same Keio South constituency. And my lord, it's indicated that a total of 355 people did, my lord, attend that public hearing. And out of those, 352 persons, my lord, supported the motion. Lastly, on that point, my lord, is to refer you to page 440 of the replying affidavit, my lord, where you shall note, not 440, my lord, I'm sorry, page 439, where, my lord, you shall note that the total responses in respect of Keio South constituency were 820. And that out of those, my lord, in support were 807. So, my lord, the views are submitted, or the submissions are submitted by my lord colleagues, my lord, do not find any favor in the report, and therefore, my lord, I'll urge you that you do ignore them. My lord, I also need to point out that public participation, my lord, is not a referendum, as well understood, my lord, and that in the words, my lord, of your learned brother, justices and sisters, my lord, in the affordable housing decision, public participation does not, my lord, necessarily mean that everyone in the country must give their opinions. My lord, that is paragraph 175 of the affordable housing decision. And that, my lord, all that the National Assembly was required to do at paragraph 176 is to give the public an opportunity, my lord, to submit their views. And my lord, you shall note that in the report, all that was done by the National Assembly. And therefore, in the fullness of time, my lord, we shall demonstrate before you that there's absolutely no arguable point, and the public participation exercise that was conducted, my lord, by the National Assembly was not only meaningful, but was sufficient both qualitatively and quantitatively. My lord, the other issue that was raised was by my learned colleague, Mr. Omari, on public participation, where he indicated, my lord, that elections are conducted at the polling stations. My lord, that submission is not true. The presidential, my lord, elections are provided for in terms of being conducted, my lord, at Article 138(2), where it states, my lord, that the elections are at the constituency level and not at the polling station. My lord, the other issue that arose from this submissions from my running colleagues is whether, my lord, the first petitioner was given an opportunity to present his reply to the public prior to the public participation. My lord, my answer to that is simple. That first, my lord, the public participation exercise commenced on 2nd of October all the way to 5th. And my lord, by the time the public participation commenced, the first petitioner had not submitted his response or lodged his response to the National Assembly. And therefore, there's no way, my lord, that response could have been availed to the public. Secondly, that, my lord, the National Assembly only avails what is in its possession. And therefore, at that point, my lord, the National Assembly could not have been accused of not, my lord, presenting to the public what had not presented to it. But more important, my lord, there is no legal requirement, and none was cited by our land colleague, that dictates that the National Assembly had a duty to present, my lord, that response to the public during public participation. And last, my lord, nothing stopped the first petitioner, my lord, from himself presenting that response to the public, as he did, my lord, on the eve of the hearing or proceedings at the National Assembly. The last point, my lord, on public participation was whether, my lord, the Senate ought to have conducted the public participation exercise. And, my lord, my answer to that is this, that under Article 118B, my lord, of the Constitution, Parliament is, yes, required to conduct public participation. But, my lord, Parliament under Article 93(1) refers to both the Senate and the National Assembly. And, my lord, you shall note that the impeachment proceedings are two-tier. That the first stage, my lord, is conducted by the National Assembly, and the second one, the trial chamber, is the Senate. The Senate sits as a quasi-judicial organ, my lord, in respect of the impeachment proceedings, and that it's not required to repeat the public participation exercise. Because if that were to be so, my lord, then it means that even this court sitting in exercise of a judicial function, it could be required, my lord, to undertake the public participation exercise.
Mr. Milimo, we only entertained you on these submissions because we had entertained other people earlier. That is the only reason we are listening to you.
I thank you, my lord. But I'm winding up on that, my lord. Yes. My lord, the second issue that, my lord, I'll invite your attention to is on the subject, my lord, of fair hearing. My lord, and on that limb, there was a challenge, my lord, to the standing orders of the National Assembly. My lord, my answer to that is simple, that there is a presumption of constitutionality of those standing orders, my lord, and that at this stage, being an intellectual stage, this court, my lord, has no power to invalidate those standing orders, my lord. In the fullness of time during, my lord, the main hearing, we shall demonstrate to you that those standing orders, my lord, reflect Article 145 and 150 of the Constitution, and that their simple duty, my lord, is to implement those articles of the Constitution. The other issue, my lord, that was raised was about impartiality of the Speaker of the National Assembly, my lord. Yes, and my lord, you shall note that the Speaker of the National Assembly, my lord, has no vote in the proceedings, and that is, my lord, under Article 122(2)(a) of the Constitution, and that submission, therefore, my lord, is not a valid submission. And, my lord, more importantly, my lord, you shall note also that at the National Assembly, the first petitioner was given an opportunity to both appear and be heard. And, my lord, he did file a substantive response to the notice of motion. And more importantly, my lord, he was given 2 hours to present oral representations. That opportunity he took, my lord. And therefore the question of there having, my lord, been a breach on the elements of fair hearing does not arise whatsoever or at all. My lord, my last point is on the nomination, my lord, of my good teacher, Professor Kindiki. And my lord, the issue was whether there ought to have been, my lord, an approval process at the National Assembly, and whether, my lord, there ought to have been public participation, as well as, my lord, the timelines that were invoked, my lord, to process the good professor. Yes, my lord, all I need, my lord, to bring to your attention is there was a ruling, my lord, by the Speaker of the National Assembly that we attached to the first respondent supplemental list and band of authorities, dated, my lord, the 28th of October this year. And my lord, you shall note that in that communication, the Speaker did address all those issues, my lord. The communication, my lord, is communication number 54 of 2024, and it's dated the 18th October 2024, where, my lord, the Speaker did address in giving guidance to the House all those issues, and I will invite you, my lord, to refer to it when you retire. My colleague, Mr. Macharia, my lord, on a light note, told the court that, my lord, I would have said weta TOSHA. My lord, I'll say that in 2032 when the right comes. I thank you, my lord, unless your lordship have any questions.
My lords and my lady, I'll proceed from where my learned friend Mr. Milima stopped. Permit me, for completeness of record, to say that the second respondent has filed an application dated the 18th of October 2022. We have filed submissions in support of that application, again dated the 18th of October 2022. And we have a replying affidavit sworn by one Samuel Joroge on the 21st of October 2024. I'm reminded by my colleagues that I forgot to mention my name for completeness of record. My name is Eric Gumbo. In understanding the application and the prayers that are currently live before the court, permit me to draw your attention to the application filed by our learned colleagues in the matter 565 for 2024,